Thank you. Be seated. Ms. Hanley, you may give the second portion of your closing. You have 31 minutes left, and I'll give you a 5-minute warning.
Thank you, Judge. Let's start by talking about Dr. Oberst. Dr. Oberst's determination in this case was undetermined. Now, the defense is asking you to believe that because she didn't find it was a homicide, you can't do so either. Let's flip that argument. Let's look at the opposite. What if we were in the circumstances that Dr. Oberst determined that this was a homicide? What if that's what her report said? What if that were in evidence? Do you think they would be standing here telling you, well, it's over? Dr. Oberst said it's a homicide, so we have nothing to argue? They wouldn't do that. They would tell you that it's your job to look at all the evidence as a jury, to look at the evidence and make a decision for yourself. And that's what we're asking you to do here. You have all the evidence. Dr. Oberst's medical diagnosis and her findings is just one small piece of the puzzle. They wouldn't ask you to rely solely on her report if there were a different finding. We also heard some discussion about the HCG. And I want to clear that up too. There's going to be 12 of you on this jury, not just one. 12 of you instead of just one, like Mr. Falk, and you should look back through your notes, should talk, discuss what you remember from Dr. Oberst's testimony, and I'm sure that you'll find that the conclusion is there's no evidence linking HCG to depression. It's not in evidence. There is no link. There is no tie between those two things. What you actually have in evidence about the HCG, if you remember where that discussion started, was the defendant admitting a couple of tackle boxes that he says belonged to Vashti Seacat. And those tackle boxes have some syringes in them, and they have some sodium chloride, and one of them has an email from Brett Seacat to Brett Seacat, an email that looks like a steroid recipe. And you have the defendant who's a bodybuilder, has been a bodybuilder in the past, has bodybuilding magazines, and he admits this in the recorded interview. This is CD number 2 at 26 minutes and 45 seconds in. Those items are Brett Seacat's. That's what the evidence shows, that the item that he tried to use to tie the HCG and the injections to Vashti Seacat actually belong to him. And you should remember that when you're considering the defendant's overall credibility. The items that he tried to assign to her tie directly to him through an email located in the box. Now we also need to clear up the position of the gun. The position of the gun underneath Vashti Seacat's body was not how you were shown a few minutes ago. It was like this. That's how it was under Vashti Seacat's body. And I'll ask you again, use your common sense to think how it ended up in that position, completely tucked underneath her left side. Now the defendant wants you to think that had something to do with the fireman who went into the home. The defendant says that Chief Drosselmeyer testified about sheetrock being all over the body. Well, that wasn't the testimony, and that's not the evidence. You can see the photo. There's some tape on her. There's some white things that's sheetrock tape, but there's not a big mountain of sheetrock on the body, as he would have you believe. There wasn't any sheetrock that moved the body around or moved the gun, and there certainly wasn't any water that moved the gun. This is again where you use your common sense. What exact angle would the water hose have to take to flip the body over from her back to her side, tumbling it just right so it tucks the gun up underneath her? That makes no sense. There's not testimony to support it, and common sense-wise, it makes absolutely no sense. You were also asked to pay attention to the 911 call, and you should. You should listen to that right away when you get back to the jury. On cross-examination, the defendant hadn't quite thought this one through. You'll remember his answers during this part of cross because he had the details memorized that he wanted you to remember, like turning the water faucet on before he grabbed the dishcloth and leaving the water on. He remembers those details perfectly, but he couldn't explain to me, couldn't remember at all how he was holding his cell phone. I asked him, he had no idea. He could not explain how he was holding the cell phone, and he couldn't explain how he was able to hold the cell phone, get a dishcloth, put it under the faucet, run back up the stairs with his cell phone, with the dishcloth over his mouth, supposedly breathing in smoke, going into the pitch black smoke that he couldn't see. This is his testimony, and these are his words to Agent Folletti, how he was able to hold on to that cell phone the whole time. And you should listen to that 911 call because it's an interesting recording of what went on. He didn't have anybody to help him execute the right background noises for that. He told you he was still outside when that phone call was made. Well, if that version of events is accurate, then you should hear the door open when he goes back in, and you should hear the door slam behind him when he goes in. You should hear him running up and down the stairs, running that he says he left on. You should hear him go into the smoke, and he tells Agent Folletti that he breathed, he took a deep breath once he was in the smoke. You should hear that. If he's breathing in smoke, you should hear coughing, you should hear gasping, and you don't hear that, you just hear his heavy breathing. You don't hear any muffled noises like he's got the dishcloth over his mouth. And again, he's on the phone and he's doing all of this, and he gets up there to a point and he can't see anything. And he says at that point he has to drop to his hands and his knees. You don't hear anything on that 911 call that sounds like him dropping to his hands and knees with the dishcloth and the cell phone still in his hands. You don't hear him dropping his phone. You don't hear any of the things that you should hear if everything he's telling you is accurate about what happened that night. Now, there was a question raised about mistakes in the case. They're taking the angle of attacking the investigation. And I want to discuss that while we discuss the defendant's experts. Okay, I want you to compare the state's case and the experts that the defendant brought you in this case. Dennis McPhail told you that the note is a forgery, and they brought Ava Sodenbaugh in. And Ava Sodenbaugh is a nice lady. She's a nice lady who was told when she started her examination that the document she was looking at was a suicide note. So that's what she has in her mind from day one. She admitted on cross-examination that Mr. Wachtel must have told her it was a suicide note, or she wouldn't have used that term in her report. Her report's in evidence. That's exactly what she called it. She's a nice lady who's told that this is a suicide note, look at it, examine it, in the background of her being uncertified, untrained, little to no experience in the criminal area, and she admitted on cross-examination that there are differences in the writing. That's the expert that the defense brought for you, and that is the expert that they want you to believe to say that Vashti Seacat wrote that note. And let's talk about that opinion, because this is a serious matter. It's a serious case. And she may be a nice lady, but she, by choice, involved herself in this case, and she gave an opinion, and she didn't just qualify her opinion or say, yeah, there's some similarities here. She went all in. She said Vashti Seacat wrote this suicide note. She gave 100% opinion. Now, if an expert's going to give you that opinion, don't you want that expert to be qualified? Wouldn't you want that expert to be certified, tested past the last 8 years, if my memory is right? Compared to Dennis McPhail, who's tested twice every year, who's board certified. Ava Sodenbaugh told you that she wasn't currently certified as she sat before you today, and at the time she did her examination, the organizations that last certified her had disbanded. They were no longer in existence. So that's the defense expert trying to tell you that Vashti Seacat wrote that note. They also brought Gene Geitzen into court. And Gene Geitzen is the expert in everything, for lack of a better way to say it. The only thing that I recall him saying that he was not an expert in was DNA and handwriting. So I guess that's why they needed Avis, because he couldn't testify to both. So Gene Geitzen is the critic who came in here holding himself out as an arson expert based on a week-long class that he had years ago, and he hasn't had any training since 1999. Now again, if this expert is going to come in here and criticize a board-certified, twice-yearly proficiency-tested expert for the KBI, wouldn't you want that individual to be qualified? Wouldn't you want them to be certified, to be trained in their area before you'll listen to that opinion? You should think of all of these things when you're examining the credibility of the defense experts. And while we're on the subject of Mr. Geitzen, we talked about duct tape, okay? And you were asked, what do we know about duct tape? What do you know about duct tape? How well does duct tape work? Do you use it on a lot of things? In your common sense and experience, have you used duct tape? How well does that keep things in? You can think about that when you're examining whether or not the duct tape had any effect on that examination, and if it did, how it affected it. The suicide and depression allegations have been refuted by every witness that took the stand. And what Connie Suderman actually told you was that Vashti Seacat was not suicidal. She said she'd had episodes of depression when she was treating her, and specifically in April of 2011, she was doing better than ever. She'd moved on, she'd made a decision, she was standing up for herself, she was taking care of herself, and she was looking forward to a lot of things. And again, remember this comment about the castle episode. I reminded you of that in the first part of the closing. But Vashti Seacat, according to Brett, they were there because she was depressed, and that was the whole focus of the counseling. But he never brought up this supposed instance where she's asking about what would be a good gun to kill herself with. Remember that. Remember that when you're thinking about the defendant's credibility. We talked about the Post-it note that's in Vashti Seacat's purse. So the photo that I showed you a few minutes ago showed you that Vashti Seacat had a lot of stuff in her purse. But what she's doing, listing on there, is planning for life insurance. She's getting divorced. She's moving on. She's being prudent and she's budgeting. What do I need for mortgage? What do I need for these expenses? She's totaling that up, and that's in her purse. That's what the evidence shows is, again, more plans, more looking ahead to the future. Has it dawned on you yet how many coincidences or how many things that are just plain bad luck for Brett Seacat that you're going to have to accept in this case in order to believe his side of the story? Let's go through all these coincidences, everything that shows you that what he wants you to believe is just his bad luck. So if it's just Brett's bad luck, the day before Vashti dies, he just happens to be torching hard drives, destroying cell phones, and practicing forgery at his office. Just his bad luck. He just happens to pick out the PowerPoint from a pile of scratch paper that's a complete PowerPoint on how to conduct fire death investigations. Just Brett's bad luck. The neighbor, Cammie Smith, just happens to be awake and just happens to, and she actually mistakes a tree limb falling for a gunshot. He wants you to believe that's just his bad luck, that Cammie thinks a tree branch falling is the same thing as a gunshot. Despite walking and reaching through fire, he has no burns, no soot, no blood on him. Just more of his bad luck. Vashti had bad penmanship on her suicide note, and she didn't leave any prints in the journal. That's what you have to believe Brett Seacat's side of this story. Just more of his bad luck. And then finally, even after sitting in the KBI for several months, the BDUs, they still have gas on them. Again, just bad luck for Brett Seacat. That's what you have to believe to take his, that's what you have to believe that what he's telling you is accurate and to go through all of his facts. Well, it's not bad luck. It's just a culmination of events. There's a logical explanation for it. And what it is that Brett Seacat couldn't take any more. He had to kill her. He couldn't control her anymore. He couldn't manipulate her anymore. He couldn't have his way. When you go back to the jury room, you can be comfortable with the evidence in this case. The state presented a case, you heard testimony about how there's over 10,000 pages of discovery, reports, documents, evidence. We presented 17 different witnesses from law enforcement, and 11 of those witnesses were KBI agents from all across the state, and 7 of those were expert witnesses in their respective fields: handwriting, arson, DNA. The list goes on, and they're from different labs: Great Bend, Wichita, Topeka, even a lab in Maryland working on the arson part of this case. We're not asking you to stretch the facts, to stretch the evidence, to try and make it fit the story. That blank slate has been filled. We've given you every angle. Every time the defense has raised an issue or tried to raise an issue in this case, we've answered. Remember all the discussion about the VW? Remember all the discussion about how that supposedly moved? They brought that up and we answered by presenting 5 photos and evidence that showed you that car stayed there the entire time. Remember how many times Agent Jeff Newsom's name came up early on in the trial? Remember how there was an insinuation that he was just going to pin this on Brett Seacat from the first day? What happened when Agent Newsom took the stand? He told you that Lot Seacat was his good friend, the defendant's dad. He said he didn't know anybody on Vashti's side of the family other than her grandfather. He removed himself as lead agent in this case because he didn't know if he could be fair when he was investigating the son of a friend. That was an implication that the defense put out there for you. And every time that they raised those issues, not because it was a problem, but because we wanted you to be comfortable with the evidence in this case, we answered. We showed you that the evidence proved exactly to the contrary. Probably didn't know the elements of the crimes when you walked into court today. Walked into court 13 days ago now. But you likely had a mental checklist of what you thought that we needed to show you. Probably included motive. Done. Divorce, threats, he couldn't get over it, he couldn't let her move on. We showed you the motive evidence. Opportunity. The opportunity was there. The opportunity was running out, and he had to commit the murder. He had to commit that on Friday night. Suspicious behavior on the part of the defendant. We have evidence of that. What's he doing the day before while he's at work? You probably wanted to make sure that there wasn't anything that you thought supported the defendant's theory. And again, every time that an issue has been raised in this case by the defense, we've answered. Suicide and depression, the evidence shows exactly to the contrary. She was moving on. She was happier than ever. The attack on the investigation, there weren't any holes in the investigation. There weren't questions left unanswered. The car didn't move. Nobody messed with the journal. None of that happened. You've heard evidence that the defendant planned and he murdered his wife. The defendant is controlling, he is manipulative, and you know what else he is? He's guilty. Find him guilty as charged. Thank you.
Ladies and gentlemen, at this time, I'm going to release you to the custody of the bailiff. Want the 12 of you that will decide this case to go in there. One of you will be sequestered elsewhere and needs to remain here until a verdict is reached. I have lost jurors during deliberation a time or two to illness or other issues, and so the alternate will have to stay here. The alternate is number 14. When you get into the jury room, I want you to first of all select a presiding juror to preside over the deliberations and to speak for you. Secondly, I want you to decide if you want to stay here for a while this evening and commence your deliberations. If you do, you might ponder how long you want to stay. If you have some idea, you can discuss that also. We'll stay as late as you want to stay if you want to stay late this evening, and we can order in dinner. If you prefer to start fresh in the morning, that's fine too, but I need to know that by 5 or so. And we'll take it from there. At this point in time then, you are released from the instruction that you're sick of hearing. It now is the time for you to confer with each other. Now is the time for you to express your opinions, and now is the time to form a fixed opinion and reach a verdict in this case. This point in time then, you're excused. Pick the presiding juror, ponder how late, or if you want to stay, and let Sandy or Stacy know, and we'll take it from there. We're in recess.